Last matter to come before the court this morning is Cedar Lane Farms Corporation versus William Besancon. As I'm sure you gentlemen are aware, because you're going to pronounce it, is it Besancon? Besancon?
Besancon.
Besancon? Really?
Yes.
Oh, geez, I'm sorry about butchering that. As you both are aware, you each have 15 minutes in which to present your case. For the appellant, you wish to retain some of that time, let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We have read your briefs, we're familiar with your case, and we're ready to proceed when you are.
Thank you, Your Honor. May it please the court, my name is Doug Tershel, attorney for Cedar Lane Farms. The appellant in this matter, I'd like to reserve 4 minutes for rebuttal.
Thank you. I'll do this.
Parties in question, Cedar Lane Farms and Mr. Besancon, have been in business for over 30 years in a landlord-tenant relationship. In the case of Mr. Besancon, it started with his father, and then he inherited the land or purchased the land. And the parties have been in business together literally 32 years. They had a lease over a piece of property, let's say it's this rectangle right here. Went along, they're still there today. Cedar Lane Farm never used a portion of the property, which the parties used the shorthand North Field. And there was a dispute arose a number of years ago as to whether or not that was still covered by the lease because it hadn't been used and so on. And that was litigated in this court, appealed to this court. Judge Weiss ruled no, that the North Field was no longer a part of the lease. With regard to the case in question, the Cedar Lane had started a relationship with a company called Touchstone, which was doing some algae production research. I won't bore you with the science, I don't fully understand it myself, but basically they were creating algae for various scientific research purposes and perhaps commercial application. And it was being done on the North Field with Touchstone, with quite a number of assets, all with some very limited exceptions, equipment, inventory, things like that, very movable, things that were heaters, pumps, pole buildings, things like that, readily movable to another location. So the relationship with Touchstone ended. Touchstone signed a piece of paper to say to Cedar Lane, this stuff is all yours, it's on there. Cedar Lane Farms entered into a potential relationship with a group out of Arizona to do some algae-related work there. After it was determined that that was no longer a portion of the leased property, it would become necessary to go somewhere else. So the sole basis of Mr. Barnard's motion for summary judgment in this case was that because the court ruled that the North Field was no longer a part of the leased premises, that the potential business relationship that might have happened on that property could not, as a matter of law, be intentionally interfered with because they were no longer entitled to be there. And they cited no facts, there was no affidavit, no depositions, no responses to interrogatories, strictly said, Judge Weiss, you ruled earlier they weren't allowed to be there, and thus there could be no intentional interference with a business relationship. The affidavit submitted by Mr. Mockemer, the president of Cedar Lane Farms, said, wait a minute, all these assets are movable. I have another location here in Wayne County. Indeed, anywhere in the world you can do this. He happens to have another very convenient, close-by location where it could be done.
Let me ask you this, is there a difference in terms of evidence of these things could be moved? There's a lot of places anywhere in the world you could do this. Is there a difference between that and providing the trial court with some semblance of evidence that Arizona State University would have been willing to? I mean, isn't that kind of just conjecture? It may be true, but is it evidence for the trial court to make a decision on?
There's no question there was a business relationship. This is not an intentional interference with contractual relationship case. There's a difference, and the difference is this is an intentional interference with a business relationship. There's no question there was a potential business business relationship being discussed. We have attached in the record emails from the folks from Arizona, and they basically said, we're not going to do business with you because Mr. Besancon is crazy and he's out here harassing us and saying this is his stuff and back and forth. And that's in the record. That's in Mr. Oppenheimer's affidavit, the email from Arizona State saying Mr. Besancon is harassing us. We're not doing business with you. They went so far as to say, we're going to tell our friends not to do business with you because of Mr. Besancon's behavior. And so, is that enough? I would say it's a fact question, Your Honor. Whether or not that is ultimately going to hold the day with the jury sitting in the jury box over here is for another day. The question is, was that properly disposed of on summary judgment? So I think the answer to your question is, that's a fact question. Whether or not I would win on that at the end of the day, I don't know. Mr. Barner doesn't know. But you have to affirm Judge Weiss's decision, you have to conclude that there was nowhere else in the world that this could have been done, or you have to conclude that these are things that couldn't be moved, which isn't true, but it's really a fact question that you can't resolve on summary judgment. Mr. Mocker's affidavit says they can be moved. And how does Mr. Barner respond to Mr. Mocker's affidavit? Very, very revealing. He says it's a self-serving affidavit. Well, hello. Aren't all affidavits self-serving? Why do you put an affidavit in the record to dispute a motion for summary judgment if it's not to help your case? Yeah, the affidavit helped his case. Certainly it was self-serving if you want to look at it that way. Now, there is case law that says, say there's 5 elements to a cause of action in a civil matter. You can't just put on an affidavit that says, I meet element 1, I meet element 2, I meet element 3, I meet element 4, I meet element 5. That conclusory affidavit may be what he was trying to refer to, and there's case law that says, your affidavit has to have some meat to it. Here it did. If the sole question is, can these things be moved, that's not self-serving in the sense he's trying to use it. It's just a fact. And it is a fact that it can be moved. They're clearly movable items, with some exceptions of ponds. You can't move a pond, it's dug into the ground. With that exception, they're all movable, and thus the business relationship could have occurred somewhere else. Whether it would have or not, whether a jury would find it was far enough down the pathway to warrant a recovery in favor of Cedar Lane is, I think, very clearly a jury question.
If there were, say hypothetically, that they had Cedar Lane Farms and Arizona, whatever they are, had decided, okay, well, we've got land down in this Holmes County, that we could do this down there, but because of what happened up in Wayne County, we're not going to do it down here. And we already had that ready to go, but now we're not going to. That's different than saying, well, we could do it somewhere else, but we don't have any specific plans, but at this point, they're so mad at us about him, they're not going to do it anywhere.
I agree that's different, but I think either one of those options is enough to support a claim going to a jury on whether or not that would have happened. If you read the email from the folks from Arizona, it's pretty clear they said, Mr. Besancon's so crazy, we're not going to do any business with you because he's claiming this stuff is his. So the ability to move it somewhere else, which is, can still be moved, but the ability to move it somewhere else doesn't resolve Mr. Besancon's harassment of the folks from Arizona, which was the interference with the business relationship.
Okay, I know you have that other case, but is there some case where Cedar Lane Farms is suing Mr. Besancon for that stuff back?
Yes.
It's a separate case.
Yes.
We haven't seen that one yet.
Correct. It's
curious.
pending. But there was a separate federal court lawsuit that was the district court dismissed it. This isn't in the record, maybe I shouldn't go into it, but so I won't. But
It's not here or there.
the question of ownership of these assets is not at issue in this case, other than to say Mr. Mockler's affidavit clearly asserts the ownership, and the complaint alleges that. And so for purposes of summary judgment, you have to assume that's true, which is in fact the case. So it's his stuff. There's 5 elements of the claim here. All of the 5 elements are met. The affidavit from Mr. Mockler lays out all the 5 elements, not in a conclusory fashion, not just saying there was a business relationship. It demonstrates what the business relationship was. the elements of the claim. The knowledge of the interferer is laid out in the affidavit. Mr. Barnard submitted nothing with his motion for summary judgment other than the prior decisions saying that the Northfield was no longer part of the lease. That was it. Now, in his reply, Mr. Besancon submitted an affidavit that basically said, I didn't know anything was wrong here, and I didn't know I was doing anything wrong, and I didn't think I was, and so on. Well, fair enough. What's that make? That makes a fact question. That makes a fact question inappropriate for disposition on summary judgment. If you have two affidavits that contradict each other, both properly submitted in the record, both credible people who were involved in the transaction, they're not conclusory. Mr. Mockmer's affidavit is not just a routine recitation of the elements of the claim. It sets out the facts that are necessary for all 5 elements of the claim. And an interesting example of the fact that it is a fact question is found in Mr. Barnard's reply, where he says, the attempt by plaintiff to create a material issue of fact saying it could have entered into a contract elsewhere is simply untrue. Well, you can't just say that and have an affidavit from his client saying it's untrue on summary judgment. That throws the test of summary judgment out the window of, is there a fact question? So, with that, I'll reserve the rest of my time for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. Please the court. My name is Brian Barnard. I'm here on behalf of William and Sandy Besancon, the appellees in this matter. I'd like to begin by saying that I believe both Your Honor Schaefer and Callahan kind of hit on the crux of our argument here today, that this is a shoulda, woulda, coulda type of complaint here. What they want to attempt to do is create some issues of material fact where there aren't any. I think it's important to begin by just stressing that this is a multi-million-dollar, I don't know, I don't want to be quoted, but $10 million, maybe $15 million was the size of this algae research project that was constructed on the north field of Besancon's property. We believe, based on the evidence, based on what was submitted, how the complaint read, and the exhibits there too, that Arizona State's only interest with Cedar Lane Farms was to use that algae production facility. You'll see it throughout their complaint that this Arizona State is a leader in algae technology, things like that. You'll see that throughout. Any business relationship between Cedar Lane Farms and Arizona State, as the trial court found, were specifically predicated on Cedar Lane Farms being able to rent or use the algae research facility.
Counsel, can we go back to your motion for summary judgment?
Yes, sure.
Okay. And in that motion for summary judgment, what did you include?
I only included the fact that because of the ruling of the trial court saying that Cedar Lane Farms had no interest, no rights whatsoever in the north field of the property, that went up on appeal, this court affirmed that. That's the only thing I included in there. That because at that point it was dispositive to what I believed in looking at the information I had from Arizona State University and what the complaint said. If we look closely at those letters from, I believe his name is Thomas Dempster at Arizona State, in the last email he actually says, if Besancon cuts this stuff out, and we're not here to argue about whether Besancon was fine in what he was saying, what he was doing, I didn't raise that for summary judgment, but certainly if the court reverses this, I think this case is ripe for leave and another summary judgment after all of the discovery is done, because there's just no way that they're ever going to be able to come up with the evidence required to get this case to a jury.
Well, and that may be, but what we have here is summary judgment.
Yes, sir.
And the first thing we have to look at is if the moving party met their initial burden.
And I think they did not, based on the affidavit of Thomas Mockemer, because I think they're just here trying to create material facts where there aren't any. Because Arizona State University, I believe, what the trial court found is that any business relationship was going to be predicated upon the ability to use this algae facility. And what I want to stress to the court is, if you were to go out on Back Orville Road today, nearly 3.5 years later, after this alleged conduct took place, guess what's still there?
Is that in the record?
Yes, well, I don't know if that's a disputed fact. The algae research facility is still standing there. The ponds, the greenhouses, the massive machinery, the $10 million in assets. And for them to say we could have simply just picked this stuff up and moved it to a different location is not possible. It's still
Counsel.
there because of this court's ruling.
Counsel, I guess that was my point. I actually wasn't talking about their burden. I was talking about yours originally. And so wouldn't that have been your burden to demonstrate that? Not just that the Northfield was no longer in the lease, but also that they couldn't use for the algae, that they couldn't move it and so forth.
I don't know if that was my burden at the onset or not. I simply looked at this as a summary judgment based on the court's prior ruling, and it was pretty clear, I think, from that any Arizona State involvement with Cedar Lane Farms went hand in hand with the use of that algae facility. I mean, they're not, and Cedar Lane Farms owns other property. They lease and still do a portion of the Besancon farms. They have a flower business, a commercial flower business. Arizona State has no interest in that. They have no interest in any other of the facilities that Cedar Lane Farm has. They're interested in producing and continuing to do the algae type of research that was originally started on the Besancon's land. The trial court said that lease is over. You have no rights to anything on that property. And this court affirmed. So now they're saying that because Besancon went out and talked to a representative whom he didn't know, that somehow interfered or stopped them from being able to contract with Arizona State at some other location. And I think it would be important for the court to closely review the exhibits attached to the Cedar Lane Farms complaint, because as you read those, as I did, it's clear, and there's no more affidavits, there's nothing besides these emails from Arizona State 4 years ago saying that, hey, we might want to do business with you. And it's talking about algae business. It's not talking about going into the flower business. It's not talking about, hey, we'll wait 3.5 to 4 years, 5, let's see how long down the road. Maybe we'll just wait and see. And if you can get these assets moved to another location, maybe we'll be willing to do business with you. There's none of that in the record, and I think that's...
There was no reason for that at that point, was there? If you can get it moved. I mean, at that time, they thought they had an interest in that.
They may have thought they had an interest, but I think Cedar Lane Farms at this point, when refiling of this lawsuit and summary judgment, to go to Arizona State, the person they're saying we're having this relationship with, and find some more evidence that, hey, maybe they were willing to wait, but we don't know. This is back to a shoulda, woulda, coulda.
Am I misunderstanding something? You filed the motion for summary judgment?
I did file the motion.
So again, I guess that would go back to what Judge Carr stated, that initial burden was on you.
And we simply looked at what was in the complaint, at the four corners of the complaint. We saw what the letters said from Arizona State. And any type of contractual relationship they were talking about with Arizona State is an impossibility.
What
It
about
has been.
a business relationship?
A business relationship, well, if we look at the last line of, I believe it's Exhibit D, possibly E, which is an email, this is right from Mr. Dempster's mouth. If Besancon leaves me alone, maybe we can do business.
Doesn't that make their case?
No.
Why not?
Well, Besancon has not, there's nothing to show that he's ever had any involvement with Arizona State after that. And they simply cannot use the assets on the North Field, which Arizona State is interested in for their business purposes. I don't have anything further, and we would ask the court to affirm the trial court's granting of summary judgment in this matter.
Thank you.
Methinks Mr. Barnard protests too much, because the thing he just cited, let me read to you. There's two emails. One's a letter, the other's an email. The first letter says, "A visit by Mr. Besancon caught me off guard. I was not expecting to see anyone. Not only was his presence uncomfortable, but his persistent interrogation quickly became harassing in nature. Mr. Besancon's presence halted our productivity," and so on, in the letter. That's pretty damning. And then he follows it up. There's a later email, and if this isn't the smoking gun in this case, I don't know what is. But he closes this email by saying, "If the situation and harassment by Besancon dissipate or cease completely, then I may be interested in reconsidering encouraging my Michigan customer to revisit a possible production facility at CDL." What else do I need? He said he was harassing him, claiming it was his stuff, saying, "Get out of here. If you're going to do any deal here, you got to do it with me. You can't do a deal with Cedar Lane." And the people in question say, "If he stops that, we'll consider doing business with you." That's for a jury to determine what that business might have been and what the damages are. Mr. Barnard phrased one of his responses by saying, "We believe." That's a troublesome way to make an argument on summary judgment. I don't care what he believes, what Mr. Besancon believes. The question is what's in the record. And the record is very clear that this could have been done elsewhere. Mr. Mockmer's affidavit says that. What I just read to you from the folks in Arizona says that. And there's nothing else in the record. There's nothing from Mr. Besancon saying that. The motion itself had nothing attached to it other than just saying it can't happen at the North Field. While we weren't thrilled with that ruling that it can't be done at the North Field because it would be more convenient, so what? It could be done somewhere else. And there's also nothing in the record saying this is $10 million worth of equipment. It's not. It's substantial. I don't mean to disabuse you of the notion that it's valuable equipment. It's not $10 million, but there is equipment there that is usable, can make money with it, could have made money with Arizona folks, and it's for a jury to determine whether or not it was Mr. Besancon's fault that he contributed to that, and if so, what the damages are. I would submit that the matter is, it's a jury trial question. May or may not prevail on that. That's what juries are for. The question is there something in this record that says it should be thrown out? Inferring, as you must, all facts in my favor, in favor of Cedar Lane, drawing all inferences in favor of a claim being made, I don't see how this was proper for summary judgment because of the state of the record in this matter. Unless the court has further questions, that's all I have.
Seeing none, thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and that of Supreme Court. Thank you, gentlemen.
Thank you.